Coast and Central time zones. Thanks for taking your lunch break for those of you in the mountains, and good morning still for the people on the West Coast. We want to welcome you and thank you for attending today's session entitled A Practical Guide to ERISA Research. Okay, so during the webinar, just remember your lines are muted, so please type any questions you might have into the questions chat box. Your presenters today are Eileen Ferenzi and Tim McCutcheon. Eileen, as you may know, is the managing partner of Ferenzi Benefits Law Center, LLP, an employee benefits law firm in Atlanta, Georgia. Ms. Ferenzi advises clients on all types of employee benefit plans, particularly focusing her practice on qualified retirement plans, benefits issues and mergers and acquisitions, and advising third-party administrators of employee benefit programs on technical and practice issues. Having become an attorney after more than 10 years as a third-party administrator, she brings a unique and practical approach to her advice. She is a member of both the state bars of Georgia and California and holds designations as a certified pension consultant from ASPA and an accredited pension administrator from NIPA. Tim McCutcheon is the publisher of ERISApedia.com and president of Vermont Compliance Labs, LLC. Tim is the founder of ftwilliam.com, the most innovative document and government forms provider in the industry. He wrote the first web-based 5500 forms package and introduced the first retirement plan document e-sign system. Tim is a member of the IRS Great Lakes TEGE Council and a former member of the Information Reporting Program Advisory Committee of the IRS. Prior to founding ERISApedia.com and ftwilliam.com, Tim's law practice included counseling TPAs, financial service companies, and other benefit service providers regarding qualified plan, product design, and compliance. Tim received his law degree cum laude from the University of Wisconsin-Madison. He's also a CPA and holds an MBA degree from the Kellogg School of Management at Northwestern University. My name's Chuck Gouge, and I'm your facilitator today. Along with me is Joanne Pacina, who will be monitoring your questions should you have any via the question board. Now, during the webinar, I think we have a slide that shows the things I've already told you a few times, that you ask your questions, remember that your lines are muted, and if we can't get, we will try to answer as many questions as we can during the seminar, during and at the end of the seminar, but if we can't get to it, or if you have any follow-up questions or comments, please feel free to email support@erisapedia.com. So take it away, Eileen and Tim.
Hello, this is Tim. I think I will start things off here. I'll roughly do the first half, and then I'll turn it over to Ms. Ferenzi. So hopefully she will interrupt me when I get things wrong. So anyway, what we're going to try and cover today are the general basis of ERISA law, how guidance gets issued, the different sources, and how much you can count on them, how to actually do research, and one thing that often gets overlooked is that you have a plan document that oftentimes will have the answers that you're looking for. We ask that you stay on the system for a full 50 minutes to get your credit. And after the CE portion, there will be a voluntary demo for anyone who wants to stay and see a quick demo of the system. So the first slide is a bit of a civics lesson for those of you who weren't paying attention in high school. The overall basis for all of our laws is the U.S. Constitution. There are three branches: legislative, which passes laws. Most of the laws that deal with business are based on the Commerce Clause of the Constitution, which gives power to the legislative branch, which is the Congress, to pass laws which deal with commerce. Executive branch, otherwise known as the President and his cabinet, issue regulations and actually carry out the laws. They don't just issue regs, they also do audits and other things to make sure you're following the law. And finally, you have the legal branch, the judicial branch, which decides cases, and the fundamentals here are based on, or the power of the judicial branch is based on the seminal case, Marbury v. Madison. At this point, we're just going to pause to give you the overview. The previous slide deals with government source items. This is stuff that you have to follow. And if you don't, you could wind up in the soup, as you say. Even the soft guidance, which we'll be getting into later, is something that you should follow, even though it doesn't have the legal force of law. Editorial is stuff that is written by lawyers and others to help others figure out what the law says. But this has no force of law. Eileen is smart, but government agencies don't need to follow what she says, and that goes for any commentator.
More's the pity. They only would.
Legislative, the two main bodies of law that we deal with is Title I of ERISA, which is that part of the law which labor is in charge of. Title II is the code portion, which is generally sections 401, anything that starts with the 4, and then there's some 4-digit code sections that we have to worry about with things like excise taxes and the like. Title I, which is labor, is mostly worried about worker rights, making sure people are actually getting their benefits, giving them a forum to sue if they feel that they're not getting their benefits. And the code is mostly dealing with tax and making sure that business owners don't get most of the benefits under a plan. And that's always kind of a tension, in that if the business owner doesn't get a benefit, the business owner's not going to have a plan. So they just have to sweeten it enough to make sure that the business owners are taken care of. The code and ERISA have many things in common. Eligibility, the age 21 and 1 year of service is common in both. The vesting rules are common. There are a bunch of other items that are common. But then there's many things that might be in the code and not in Title I, or in Title I and not the code. One sample is Code Section 410B, which is a coverage rule. You only find that in the code. And the other thing is only Title I will let people sue. So if a plan fails coverage test or ADP test, that doesn't give the right of anybody to sue the plan to make it right. You only can sue for those things that are in Title I, such as if you are left out of the plan beyond age 21, then you can sue under Title I. In the U.S. Code, the IRS titles are found in Title 26. They have the same numbering. So Code Section 401 is 26 U.S. Code 401. DOL, on the other hand, is a little different numbering. Title 29 is made up of various types of laws, and the numbering there, I think, starts in the thousands or somewhere around in there. So Section 3 of ERISA is actually Title 29 USC 1100 or something, or 103 or 104 or something like that. The statutes are the ultimate source of all law, so you can't blame the IRS for the ADP test. It was Congress that brought into place Code Section 401(k)(3). IRS only has the power to interpret the law. They can't make law. So be careful when you're in testing season now and you want to blame the IRS for the ADP test. They don't have anything to do with it. If you want to get rid of it, you have to go write your congressman. The basis of the Internal Revenue Code for the things that we deal with, Section 401 is the capstone. It is the numero uno statute that we worry about. It's extremely long. I think if you were to print it out, it would be 15 or 20 pages. Section 402 is dealing with the taxation of money out of a plan. 403, the most principal part of 403 is 403B, which deals with 403B plans. 404 deals with deductions, and things like 417, qualified joint and survivor, is actually hooked into 401 because 401 says that you have to follow 417.
Yeah, if you look at Code Section 401A, it's sort of a list of the plan's greatest hits. You know, that is the thing that if you're looking for whether or not you violated a qualification requirement, what you want to do is look in Code Section 401, and it will list references to other sections that are impacted with regard to qualification. So, for example, 410, which deals with participation and coverage, there is a section within 401A that says you got to go obey 410. So 401A is really kind of the index to all the things that follow that are qualification related.
ERISA, on the other hand, you have a definition section. Most people probably know Section 3, which is the definition of a pension benefit plan, I believe.
3(1).
3(1) is a pension benefits plan. Reporting and disclosure are in the hundreds. This is where you find the rules that say you have to file a 5500 and you have to do things like give out a SAR. Minimum eligibility investing standards in the 200s, mostly parallel what you find in the code. There are things that are present there, but not in the code, but it's very, very similar to Section 401. Minimum funding is currently similar to Section 430 of the code. Did I get that right? Mm-hmm. Eileen, it deals with funding in pension plans, defined benefit plans. Fiduciary responsibility are in the 400s, where you will find things like prohibited transaction, the prudent person rule, and those types of things. Mm-hmm. And finally, the 500s deal with the rights to bring suits, civil penalties that DOL can pose on a sponsor and others. Is that pretty much summing up there? Okay. Executive branch, responsible for carrying out the law, mostly issuing guidance and other items, and also doing audits and making sure that people are following the rules. We have basically three general categories here. These, you won't find these in a book anywhere, but this is just a way of looking at it. Regs are at the top, and then there's other vetted guidance, IRS revenue rulings, DOL advisory opinions, and by vetted guidance we mean that generally there's a lawyer at the agency that has taken a look at it and signed off on it. And I'm not sure if revenue rulings have to go to Treasury like regs do, or whether that's something that IRS can do on its own. But any reg or any IRS reg has to go through Treasury, and I'm not sure the other rulings do have to go through Treasury.
One of the things to know about regulations is there are actually two types of regulations. One is called a legislative regulation, and what that is a situation where the law itself will have language that grants authority to regulate to a specific agency. So you'll see in the law it'll say you can do this and that, and the Secretary of the Treasury is authorized to issue additional regulations. When you have that kind of provision in the law, then the regulations take on a level of reliance that's pretty much equivalent to the law. On the other hand, if there's no such statement and the executive branch does regulations basically on its own authority, those are called administrative regulations, and those have something less than the same level of reliance as do legislative regulations. However, those are very clear statements of what the administrative branch is doing in terms of regulation. They are given incredible deference by courts, so you can't just like say, well, I don't like this regulation, so I'm not going to follow it. It's only the IRS's opinion. And if it goes to court, you're going to have a lot of presumption against you. You're going to really have to show that those regulations are incredibly beyond the level of authority that the Act gives them in order to have those not be authoritative.
And going from top to bottom there, actual regs, other vetted guidance, and then the soft guidance things that show up on a website. As a practical matter, if you're stuck in an audit, you're likely going to have to be held to follow even the soft guidance. Where that doesn't matter so much as, let's say you're in an audit and you actually want to litigate it, then it starts to matter that this is just something on the website and IRS really can't hang their hat on it. The courts, Marbury v. Madison, this is probably the most famous quote in constitutional law. It is emphatically the province and duty of the judicial department to say what the law is. And any sort of non-constitutional case can be overturned by Congress. So if Congress passes a law and they think that the courts get it wrong, they can just pass another law to make sure that the courts understand what they're trying to do.
And a really good example of that would be in the kind of earlier stages of rules, when control group rules were the only things that talked about whether or not two companies were related. A couple of doctors decided to set up a situation where they each owned 50% of a partnership and then had their separate medical practice, and they put their plans in the medical practice, and they were the only employees there. The IRS audited them. The IRS said, that's no good. They said, we're not a control group. We only have ownership over 50% of the law partner or the medical partnership, and they were right, and the tax court said they were right, and Congress didn't like that, and lo and behold, now we have the affiliated service group rules, which were passed by Congress. So that's a real good example of a situation where the courts decided what the law was, the regulatory agency didn't like it, they went back to Congress and said, give us something better, and Congress ostensibly gave the IRS something better, although I think that that's a matter of judgment, but whatever.
And what you mostly find in the courts are Title I cases. I think the most common suit now are fee cases, right?
Yeah, they're pretty common now. Yeah, right. Or stock drop cases are the other one.
Stock drop, yeah. right, that sort of thing. But on the code side, it's relatively rare in that we may see more of that, though, with larger companies where they don't have a favorable letter, that when it comes time to challenge something, they may have to go to court. So while IRS is saving money by not giving out favorable letters, it may wind up costing everyone more in the long term. There are three levels of courts: tax court and district courts. The decisions of these courts are not precedential or binding. They just deal with the parties. The next level are the courts of appeal. There are, 11 or 12 courts of appeal in the U.S. They cover various states, and they are binding in that circuit. And and other courts in other circuits will oftentimes follow them anyway.
Right. So you may find that if you do something and you're in the Ninth Circuit, which is basically the West Coast, that those courts of appeals have made a decision that what you've done is okay. But when you go to the 11th Circuit, which is, for example, where I now live in Georgia, the 11th Circuit has said it's not okay. So that's what's called a split in the circuits. And people will then, you know, if you're going to do it, you're going to do it in Georgia as opposed to doing California or whatever. That will exist for some period of time, but if it becomes an issue, that's a common way that a case goes to the Supreme Court. And the reason for that is what you're about to say, which is that
everyone's got to follow the U.S. Supreme Court.
That's right.
It is the law of the land unless Congress overturns it.
That's right. So if the Supreme Court says, yeah, the Ninth Circuit was right, the 11th Circuit was wrong, everybody's got to follow that. The 11th Circuit has to just get over whatever it was they were saying before because it's no longer true.
Executive guidance, and as we said, there's sort of three, levels that just our own little way of looking at this. That's not any sort of a legal basis for splitting them out in those three, but regulations are at the top. They've, been looked at with lawyers. They've gone through all sorts of hoops to be issued. Other vetted guidance, you're generally going to have someone at the agency, some lawyers at the agencies sign off on them, and then there's the soft guidance, the stuff that you see on the websites and that sort of thing. There's generally a lot less clearance. The bad news is it hasn't been looked at a great deal at the agencies. The good news is they can get it out quickly. So if there's some pressing issue, they'll oftentimes just put something up on the website.
You generally won't find any great departure from settled stuff in soft guidance. Usually what we'll see soft guidance on are things such as right now on the Department of Labor conflict of interest regulations, we've gotten the FAQs from the Department of Labor on several issues. That's soft guidance. That's basically a listing of things that will clarify to some extent what the regulations say. It's based on pretty much settled discussions that the Department of Labor has, but it does not have the same force of reliance that you have with regulations, for example. On the one hand, if you don't follow the FAQs, they will probably sue you if it has any value to it, and they will sue you on the basis that this is what they believe the law says. But at the same time, the courts don't have to give the same level of deference to that. They're able to say, well, that's great, DOL, that you said that, but that's not what we think the law says.
And Eileen, if I can part in right now, we do have a question from the audience. The question is, where do the Internal Revenue Service memos land in the executive guidance order of importance?
I'm sorry, where does the IRS what land?
Where do the IRS memos land in the executive guidance order of importance?
They are less than regulations, certainly. They are usually the letters tend, if you're talking about private letter rulings, for example, those are rulings that have absolute force from the IRS with regard to the people to whom the rulings are written and with regard to the IRS. They have absolutely no force whatsoever to other people. So I could apply for a private letter ruling today, get a positive response. Tim could go and look at that positive response and say, oh, okay, I'm everything about me is the same as what Eileen did, and go forward. And theoretically, if he gets audited, the IRS could say what you did is wrong. And if he said, well, but you let Eileen do it, sort of like when my kids say that to me, it's like, well, that was Eileen, this is you, and I'm not letting you do it. In that regard, there's also other things that are memoranda, which is basically occurring. Usually, they're called like technical advice memoranda. That's a situation where an agent within the IRS comes up against an issue, usually on audit, and asks the national office to give them their guidance on that. And the national office guys all get together and discuss it, and they send down a memorandum to their office saying, this is a technical issue, this is the way we want you to deal with it. And again, I think that is only given certain, relatively small deference by the courts because it's simply an expression of opinion on the part of the agency. But on the other hand, if you're in the agency, it's what your boss told you. So it will have significant impact in terms of the way that IRS agents will deal with an issue in the field. But if you want to go further and sue about it, it will have only minor deference given to it by the courts.
Okay, and then a follow-up on that asks about the impact with internal IRS memos like the Carol Gold memo.
Yeah, that's again, it's a little bit less formal than technical advice memo, but it's exactly what I just said. Carol Gold, when she was the head of the employee plans group at the IRS, sent out a love note to everybody that worked for her that said, I'm really worried about people having employees that they hire for, a blink of an eye, and then including those employees to help them pass their coverage testing and their non-discrimination testing. And so if you see these kinds of temporary employees happen, that should not be the basis for somebody passing a test. And what that did is it set a tone for the agents when the agents review cases. So if your main concern when you're doing work is that you're able to stand up on audit, that the client's not going to be threatened on audit, then you're going to look at the Carol Gold memo with a lot of deference. On the other hand, if what you're trying to do is push the outside of the envelope and you don't care if you end up in litigation because that's okay, you like to live on the edge, then maybe you would give that something less deference. Now, I got to tell you, I don't know a whole lot of people who purposefully do the latter. I mean, a lot of us as practitioners try to push the outside of the envelope as close as we can get, but usually the outside measure is we don't want our client to get sued, or we don't want our client to be Exhibit A in the lawsuit, so we tend not to go past that. Other things that I would just mention as a practitioner is that there are times where I will let a client choose how close to pushing the outside of the envelope that they'll do, and then a lot of my judgment that I'll give to a client when I'm telling them what is likely to fly and what's not likely to fly will again be structured around what the IRS has said, either formally or informally to let them know if this comes up in an audit, they will push you to court, and so you need to be prepared to go to court on that. And so that's basically the way that it works in real life. Okie dokie. All right, back to Tim.
Thank you.
Okay. Administrative Procedure Act is, I think it was passed in the 70s or 80s, I'm not sure when, formalized the issuance of regs. And what you will see now from IRS and DOL is there'll be a publication in the Federal Register for proposed rules. And they may, IRS, you have to read carefully when they issue a proposed rules. They may say that a taxpayer may not rely on these, or they may say you may rely, and that's a huge difference and something you have to take into account. And generally, a really good commentator will point out whether it's a rule that you may follow or you can't follow.
Right, so, for example, there just came out, these are actually proposed regs, but some proposed regs came out recently saying that you can use forfeitures to fund QNEX and QMAX and safe harbor contributions, and it specifically said in the text, you can go ahead and rely on this while we're waiting for this to become finalized. If they didn't say that, then you'd have to wait for it to be final to rely.
Yeah, excellent point. Then after that, there's a period of comments, and IRS will hold a hearing. You can send in comments. You got to send in 11 copies or something to some address, and you can comment on it. And then after that, they may or not listen to you, and they'll come out with the final rule published in the Federal Register.
When you read the final rule, what's kind of fun, if you have made comments or if you're part of ASPA and you're even working with the Government Affairs Committee or something, is that the preamble to the final rule will discuss the comments that they got and what they did with them. So they'll say, we received comments that said this, that, and the other thing. We thought they were stupid. We ignored them, and so we went ahead with our original rule. Or sometimes they say we were compelled, and we changed the rule to do that. They put it more officially than that. They don't say we thought it was stupid. But the point is that you can follow what actually happened from those comment letters when you read the preamble, for what that's worth.
And that leads into this slide here, in that when regs are published, both final and proposed, the agency will publish a great deal of language known as the preamble, which is not the regulation, but they go and they tell you about why they did certain things and why they didn't do certain things. And it is really a good place to go look if there's some issue that's not answered in the reg. You may go and read that IRS said that they didn't put anything in the reg because they don't know what the answer is, right, or they didn't put it in the reg because they're going to issue a reg later, or something like that.
Or sometimes they tell you what the reg says, so you read the reg and the language is not clear to you. You go back to the preamble and you'll see that, oh, that's what they meant. By the way, one of my favorite puns is that Darren Watson calls these pre-rambles.
Yeah, and On ERISApedia, any reg issued after 1993 will have a link to the preamble. So anytime you're looking at a reg, it's not making any sense, or you can't figure out what they're trying to say, definitely you want to click on that link to try and find out what the background is.
We do have a question here. If we can just take a moment. The question, a trolling question, as it says, why would the agency go through all of the pesky rules about advance notice and collection of public comments when all it has to do is publish FAQs from on high, which appear somewhere on their website? Perhaps looking for a comment.
Okay, well, let me try that, and then you tell me if you disagree. I think that one of the most important reasons why is, first of all, they're compelled to by the Administrative Procedures Act. But secondly, it's really easy to demonize the people in the government. That what my experience has been is that they have a goal that they're trying to achieve, and if they are told, fairly repeatedly by people that their regulation or their guidance doesn't precede their goal, doesn't go towards their goal, but on the other hand is contradictory or has unintended effects, they seem to take that pretty seriously. Now, that doesn't mean that they're going to listen to whatever you say, but I think that particularly, for example, if you read the final conflict of interest regulations from the Department of Labor, they look significantly different in many ways from the proposed conflict of interest regulations. And when you read the preamble, you see a lot of that is due to the commentary that they do. So I think that that's critical. I think the other thing is that the government does not want to have to litigate all the time. So they don't want to just put out an FAQ that has very little force. They want to have a situation where they can set this in stone and they don't have to fight with you about it every time they do an audit. So I think that's the other reason why they only use the FAQ style if they are not intending to put the resources and energy and time into coming out with really formal guidance.
And usually the things you find on the site are the things where you're actually splitting some hairs. It isn't like it's some broad overall concept. It is something where they have issued a reg. It's not quite clear maybe, and IRS will put up something on the website to say, well, what we meant by that is this.
Right.
Anything else? Yes.
That's all. Thank you.
Okay. Vetted guidance from IRS. Revenue ruling sort of sits at the top of the list of vetted guidance. It's not a reg, although IRS at times tries to give it the force of a regulation. Courts pretty much beat them down anytime they try to do that. But, revenue ruling, IRS put a lot of thought into it. This is pretty much what they think. And then under that, we have notices and announcements. Basically, you got to follow what they do. So that's what you can and can't do, and how you do it are found in revenue procedures, such as employee plans, correction system, and favorable letter. Some soft guidance, I think we talked about private letter rulings or technical advice memoranda. I think that was covered pretty well, and other forms of soft guidance that we've talked about, memos, publications, Qs, and As. DOL side, we haven't really talked about their vetted guidance. Advisory opinions are binding on the DOL and the applicant, but those I think are treated pretty seriously in the industry, like advisory opinion that went to Bob Toth about MEPs. I think everyone knew that you couldn't do an open MEP after that, even though that wasn't a reg. It was just, advisory opinion that.
Yeah, advisory opinions are pretty strong.
Yeah. Field assistant bulletins really aren't guidance on law. It's just telling staff what to do when they find certain situations. So it isn't law, but it's telling an agent what that agent is going to do or not going to do when they're pressed with an issue. And then DOL also has the how to do it, voluntary fiduciary and delinquent filer. And then the soft guidance is very similar to IRS, the website's publications, Qs, and As.
Okay, so again, just reiterating, everything that we talked about so far is stuff that has to do with the government, and it is stuff that has some sort of variation of reliability as to what you can do. Remember that all interpretations and explanations of government material, whether it's from me or whether it's from Sal Tripodi or whether it's from CCH in their description area or the eSource and ERISApedia, All of that stuff is interpretational. It has no binding precedent whatsoever. So if you go to the IRS agent and you say, well, it must be true because Eileen said it here in this published thing that she did, they'll look at you and say, really? Well, that's really nice, and I hope Eileen's right, but it's not compelling to me at all. I've said before that there are times where there are people that have such good relationships with the IRS that they ought to just put what they want in their publication and it can get quoted and everybody will agree with it, but that's really not true. So it's really important that you consider the quality of the author. Also, books that have citations in them allow you to go look at the cited material and make sure it says what it's supposed to say. Lawyers won't ever take, or let me put it this way, a good lawyer generally will never take the opinion of somebody in a treatise as being law. They will always trace it back through the citations to see what the actual law says because they want to make sure that they're standing on all fours with that. So when you're looking at editorial material, like I said, never trust a blanket statement. Always look for the source. And make sure that you read those kinds of sources to see if it says what the author claims that it says. Because even if, and here's another point, is that sometimes it's not what the author said that was wrong, it's the context in which they said it, and you're taking it out of context. So you'll see something, you'll be looking, you'll be doing a search, you'll see a one-sentence thing that seems to say exactly what you think it's saying, off you go running. If you don't look for the context in which it's in, you don't find out that it only applies in that context, and you're nowhere near that context. So you want to make sure that you're looking for things with specificity, and just make sure that it's being quoted correctly for the thing that you're quoting it for. The internet, one of the things that you got to be careful of is that the internet takes from everywhere and it doesn't necessarily judge who's right and who's wrong. So I could get on the internet, do a posting on a blog today that says nobody has to comply with Section 415, and if you go searching for 415, you might get that statement and you're off and running. Well, again, I don't know what I'm talking about. I'm just some crazy person talking on a blog. So you want to be very careful about that. Again, if they cite to something, go follow the site. But I would never take just some blatant statement on the internet that I did in a general search as being proof of anything. It's just to be used for helping me find where I'm going. And again, curated paid services such as ERISApedia, the ERISA outline book, the answer books, any of those things, my DC1, DC2, DC3 books, all those kinds of things, again, are people talking, and hopefully we're right, and hopefully we've been vetted by other people, but God only knows. So be sure to go follow those to the citations. Moving onward. Okay, so how do I do research? A lot of people, one of the concerns that you have is that you really don't know what to do. You've got this vast amount of data out there, but it's sort of this big amorphous mess. So we thought that we'd talk about how you do research. And I should mention here, by the way, when you go to law school, your first semester in law school, and in some schools, both your first and your second semester, you have a class that's a full class that teaches you how to do research. And you'll have a lesson every week where they'll tell you to go look something up, and they'll plant Easter eggs around for you to find, and you have to go research until you find them. There are going to be times where you're going to be able to find what you're looking for on the first pass, and there's going to be times where it's going to take you all over the block, and you just got to do the best you can. So this is the way you do it. First of all, you want to get your facts because you want to understand really the question that you're researching. And I will tell you, again, as a lawyer, it's not at all uncommon for somebody to give me a one-sentence question, and when I dig deeper, that question is not really what they want to know. They want to know something different. So getting the facts of what's going on is important. Defining what it is that you're looking for, your goal, is critical. Spotting issues in your question is really critical. Just understanding what it is you're looking for, framing your question in a way that makes it succinct enough to research for, and then you start looking, and then you just repeat until you narrow things down to what you're doing. And I'm going to show you some actual practical searches for a moment. A couple of things to look for when you're looking at research tools. First of all, speed of access. If you have something that you have to do 50 clicks to get to anything, that's probably an annoying system, and you probably don't want to do it, and you're going to get discouraged really quickly. So you want systems that give you fairly quick access to where you want to go. You want a system that clearly separates governmental sources from editorial sources, that you don't have to wonder what's in the law and what is actually correct or what's in the description. Coverage, how much is it covering? Does it cover what you need? As an example, there is a computer system that's used by almost all lawyers called LexisNexis, which has pretty much anything in the law. I deal in ERISA and the code, and so I have systems that I use instead of Lexis because I don't need to know what the state law is with regard to transportation systems in East Idaho. It's just not something I'm ever going to look at, so I'm able to use a system that's much more narrow than a generalist litigator might use. And just as a cheap, shameless plug, ERISApedia has over 9,000 searchable documents. So it has a pretty broad cross-section of what you do in retirement plan searching. And then also you might want to look for the customer service. How accessible is it for you to ask questions for things? So if you're looking at sort of how things are covered, this is an example of ERISApedia, and it's really not that different from other systems I use. But basically, it has on top the e-sources. E-source is the ERISApedia word for treatises or editorial material. That's where we've got descriptions of things. I've written quite a bit in the qualified plan e-source, and I'm continuing to write in that. So what you're reading there is what Eileen has to say about things. Then the second section is where the government source material is, and the last section we have some free stuff like our flashpoints appear down in the free stuff, as do some work by other law firms and things like that. You are able to search, and if you just let me go back to the last slide for a moment, you're able to open up any of those items and search within those items, or you can do a search request giving some words and saying, show me where this is. And that's the two different ways that you're going to go about things. Sometimes you're going to go about things by looking at the material because you know where to find it, and other times you're going to be saying, I have no idea where I am, so take me, Calgon, take me away. So moving on. So what we have, that general click qualified plan e-source was sort of the forest thing. This is where we have the editorial stuff about qualified plans. When you open that up, it gives you the various chapters, and you can open those up and you get to the various topics. So if I knew I was dealing with an issue that had to do with participation, minimum age requirements, I could go to the minimum participation requirements, open up where it said minimum age and service, and lo and behold, the very first and second section deals with age requirements. So that would tell me that. Onward. Again, where do I start? It has a lot to do with what you know about what you're looking for. So, for example, if I know that what I'm talking about deals with a code section, I might start my search looking in that section itself or searching the e-source or the other code guidance for that particular section. So if I knew I was dealing with 401k safe harbor plans, I know that's in 401k 12 and 401k 13, and I know it's found in Treasury Reg 1.401k-3. So I might just open those up and read it, or I might look within them for the topic that I'm talking about. I can also search, again, like sometimes I know that I'm dealing with something that has to do with a safe harbor plan, but I know it's not in the code and regs. It's in some other stuff, I don't know where. I could search the IRS other section in its entirety and look for a reference to that code section or to those words and find out what else the IRS has to say about it. Or I can just go back to the e-source and look for the stuff there. If I have no idea where an issue appears, then I can start searching in the e-source. And so, for example, let's say a client says to me, I want to know whether participants have the right to divest their employer securities in their account. Now, I don't know whether the right to divest is in the code or whether it's in ERISA, or whether it's a rule at all. I think it's a rule. I heard that sometime. I'm not really sure. In that case, I can go into e-source, type the phrase right to divest employer securities, and it, as a matter of fact, will direct me right to Chapter 18, which discusses this issue in detail and gives me citations. So that would be a very lucky search. From the e-source, like I said, I can link both to the ERISA sections, which deal with the fact that employees need to be advised of their divestiture rights, as well as the code section under which the right actually exists. So it'll take me to both places where I'm not, because I haven't narrowed my search yet. Moving on. Really important. Searching is not a magic bullet. You may have luck sometimes and go directly to something, but it takes time and practice. And I will tell you, it's sort of like working out. The more you do it, the easier it gets. So you want to start with your broad search, narrow down as you go along. Just keep repeating with narrower searches till you find what you're looking for. Obviously, if I put in a phrase and it comes back with 1,200 documents, I am not going to search every document for that. I've got to find a way to narrow that, and hopefully I'm going to show you some stuff about that. The problems people usually have is that they put an entry in, and either they get too few results, so it doesn't embody what you have in there, or you get too many results. You get, again, the 1,000 documents. And the trick is to figure out how to widen and how to narrow your searches. And again, a lot of that comes with time. And one of the problems, like I'm going to show you some stuff, but it is a little bit canned. I mean, I'm going to show you exactly the steps I went through to get there, but at the same time, I don't show you the ones where I never find what I'm looking for. And that's going to happen on occasion. So if you find your search is too narrow, you try to broaden it somehow. If your search is using some terminology, what the best thing to do is try to find out the terminology that the organization is giving you. Look for synonyms and other phrases. Look for misspellings, things like that. And then also you might want to see if you have too narrow a set of things, see where they refer to, and maybe if you go back to that, you'll find the broader stuff that you're looking for. So again, if I look for trustee in all of ERISApedia, I'll get 1,836 results. That's not going to help me a lot. On the other hand, if I look for trustee fiduciary duties, I'm going to get 21 results. And by the way, they're mostly in one chapter of the e-source. That directs me to where I'm going. Also, the more you use a system, the more you get conscious with the terms that people use. So, for example, if you're doing a search that has something to do with 401k salary deferrals, you'll notice that both the code and the regs and people in discussions and people in letters and, stuff in treatises will use all kinds of different phrases like salary deferrals, employee deferrals, elective contributions, 401k contributions. So knowing in your particular, because you've done research in the system before, how things are referred to will help you. So phrasing gets helpful. So let me give you a couple of examples, and you'll forgive me a little bit on this because I'm doing it in kind of an odd way. And I'm going to use ERISApedia again just because they're our sponsors. Okay, so my first search is, let's say somebody came to me and said, Eileen, I'm going to change vesting schedules. What do I have to do to change a vesting schedule? And first you hit a wrong key. Where's my escape button on this thing?
You just press cursor in the search bar.
Okay, there we go. All right. So I don't know where that is, say. I don't know if it's ERISA. I don't know whether it's in the code. I'm pretty new to this stuff. If I just go to the search bar, and by the way, ERISApedia just happens to open up looking at qualified plan e-source. That's the first place it's looking. If I didn't want to look there, I can either check additional boxes or I can check different boxes. So this I'm going to do. So I type in the phrase vesting change. And hopefully I typed that right. No, of course I didn't. There we go. Vesting change. Okay, I do that. I hit a carriage return to search, and I come up with anything that's in the qualified plan resource that has those two words in a given module. And if I look down, lo and behold, I find right here is talking about vesting schedule may be changed to when otherwise would be permitted. However, in changing the vesting schedule, the rules regarding the amendment of vesting schedule described in Code Section 411A can apply. So this looks like it's going to help me. I click on that. It will take me to where I was. Where's the top WC to be, and it talks about it. It gives me links to the code section 411A10, which talks about changes in vesting schedule if I go down further, because it said A10, so I need to go down to A10, which will be nice and highlighted when I get there. There's 7, 8, there we go, there's 10, and lo and behold, it says changes in vesting schedule. So that's dealing with exactly what I cared about. If I go back to Chapter 9, which I can do by going to the tab here, but I could have done it by using the back key, it also gives me a regulation to look at. It also tells that Chapter 15 has a whole discussion of this. So if I go to Chapter 15, well, I get this whole chapter portion on changes in vesting schedule. So that would take me where I needed to go. So that was an easy search. Another easy search is somebody comes to me and says, Eileen, let me go ahead and just clear the search. Okay. Somebody comes to me and says, Eileen, can I make non-cash contributions to the plan? We don't have cash, but I have this great piece of real estate that I'd like to contribute to the plan. And for some reason, these rules actually changed when I was a young lawyer, and so I remember it really well. So I know the answer to that right off the top, but say I didn't. Again, I have no idea where it says whether or not I can, so I'm going to start out in the e-source, and I type non-cash contribution. Now, in this particular situation, hold on. Sorry, screwed up. Press F11, sorry. Okay, there we go. Let me fix my typo. When I type words that a lot of people put hyphens in, I don't type with hyphens. It's because I do a lot of publishing in journals and stuff, and supposedly the new in thing is that you don't necessarily hyphenate. So I type the word non-cash contribution, and I search for it. And I get some stuff, but when I look at it, it doesn't really do what it's not testing your allocation of compensation. It's not ADP, ACP safe harbor requirements. So I'm not getting what I'm looking for. So I say, well, maybe they are not as evolved as I am, and they still use hyphens. Okay, so I do that now. And now what I get is a lot more issues, and this is an example of broadening your search. And lo and behold, here it is, contributions other than in cash. And so I can click on this. This will talk to me about stuff, and it takes me to the seminal case about this, which is Commissioner versus Keystone. And actually, Keystone says that it is a prohibited transaction if it's a required contribution. Well, I've got a profit-sharing plan. It's not a required contribution. What do I do with that? If I go to Interpretable in 94-1, it talks about defined contribution and welfare plans, and it will tell you that they still, if I remember correctly, consider that it's a PT, if I remember correctly. So there it is. I got where I needed to go using the eSource. Now let's say, let me just, I just want to get rid of all this stuff so I'm clear. Let's say that, okay, those are really easy, Eileen, that's really cute, but my life is never like that. Show me one that is more confusing than this. And I've got one of them for you too. So somebody, and actually this is a real case that came up, somebody else directed me to the right question. I asked somebody else in the office to look at this, but I thought, well, what if I had to research this? What would I do? So let's say that somebody comes to me and says, I have a case where the profit sharing plan has a last day requirement. It's a 401k plan. It's a cross-tested plan. Golly, does the person who is eligible to make deferrals but is not eligible to get a profit sharing contribution because they're not there on the last day, do they need to get a gateway? And I go, golly, I don't do calculations anymore, so I'm not sure. Let me go searching. Well, the first thing I did is looked in eSource under gateway because I just wasn't really sure if the gateway was found in 401k, whether it was found in the 401A4 non-discrimination rules. I'm not really sure. And lo and behold, I hit in gateway, and it gives me a whole bunch of stuff here. And it's talking about the minimum allocation. That looks kind of good. Okay, I see that. So let's see. Hold on, I want to remember how I got to the next thing. I think I clicked on this. I thought I had this written down really well. And here it's talking about gateways, and it says they left questions unanswered, and must all NHCEs receive the allocation. And here it refers me to the preamble. So I click on the preamble, and here it is. Great. And I just go looking down it, looking for where it talks about it. And I believe, actually, I thought it was on the second page. Yeah, it talks about, it's in section B, actually. Where is it? There it is, B. Gateway for cross-testing of new comparability and similar plans. And when I look at this, it has language that talks about each NHCE must receive an allocation. Now, that may be enough for me. That may mean any NHCE has to get an allocation. I'm good with that. Okay, so I got to give it to everybody. But let's say, for example, that I'm questioning now, well, wait a minute. What if I'm an NHCE that has other things involved? That just seems too broad for me. I don't like that. So let me go back. And, oh, I'm sorry. Hold on. Let me go back to here. I apologize. Hold on. So what I'm going to do, it just bothers me. I'm going to go back to the regs. I did want to go back. I know from looking at, oh, fudge. I'm sorry, guys. There we go. They were talking about 401A4. So I go to IRS regulations. I go to 401, and I go to 401A4, and here it is, and it talks about, there's a section on cross-testing, which is further down because I'm not at 4, is 8, cross-testing. Okay, that's really cool. That looks good. Non-discrimination benefits for defined contribution plans. I look in that. It talks down here about gateways. Hold on. What did I do? See, this is what happens sometimes. There's my defined contribution plan. I know it's here.
Yep.
There's a broadly available. The plan has age-based, plan satisfies. Minimum gateway of B1 4I. There it is. So I go to B1 4I. I passed it, I think, didn't I? No, maybe I didn't. Sorry, B1. No, I'm in fudge. Hold on. B1 I. Double I. You can tell I'm far away from the screen. Triple I. Right? I haven't gone past B yet. I know I'm running out of time. I know I am. Here it is. Is that it? The allocation reach employee? No. No, that's not it. Fudge. There it is. IV. I saw it. No, that's not it either. Okay, go back up, Eileen. I'm sorry. I knew this was going to happen. This is why I wrote all this down. Come on. A, B, 1, I, double I, triple I, A, B, 1, 2, C, 2, 3, D, 1, 2, 3, 4, E, 1, 2. Okay, now it's getting ridiculous. I'm sorry. It's in here. Anyway, trust me. Okay, trust me. I'm going to find it when I get out of here. But basically, what it does is it ends up referring to what an NHCE is defined as in the regs, and that's in code section 1.401A4-12. So I come back over here. I go to 12, into definitions. I want what an NHCE is, so I look under N. It comes down here and it says, an NHCE means an employee who's not an HCE. Thanks a lot. What is an HCE? So I go back up to HCE, and this is the important point, is it says HCE means a highly compensated employee Who benefits under the plan within the meaning of 410B3? Well, now it's not just HCEs. It's got to be an HCE who benefits under the plan. So it's any non-highly compensated employee except for an HCE who benefits under the plan. Okay, I'm good with that. Let's go to 410B3 to see what benefiting means. Oh, and by the way, yes, this is another thing, is that when we talk about HCEs and NHCEs in this, if I go to employee, this is critical. Come on. Because it said any employee who's not an NHCE, it says, with respect to the plan of a given year, employee means an employee who benefits. So we're back to this. In order to be an NHCE, I have to benefit. So go to 410. I go down here to 410, and it referred me to 410B3, I believe. Is that right? Let me just double check.
Yep.
Employees
and forward who benefit.
Yeah, 410B3. Okay, and if I look in 410B3, which is down here, it says employees benefiting under a plan. When I look at that, it says the employee is treated as benefiting under a defined contribution plan if and only if for that year. In the case of a defined contribution plan, the employee receives an allocation that's taken into account under 401A42C2, and I tell you because I'm getting short on time, if you look at that, it includes any contribution or allocation.
1 penny.
1 penny. So now I've got somebody who is eligible to make contributions in an employee deferral situation. Those are considered to be employer contributions once they're allocated. Boom, that person gets a safe harbor contribution. So that's an example of how I'll follow things around until I get down to the bottom until I see it in clear language. I thought that the regulation, or that the actual regulation and the preamble both were pretty close to what clear language would be, but I wanted to prove it to myself, and so I followed it all the way through, and that's what we do. Don't forget to look in your plan document, because if something is allowed in the law but is not allowed under your plan, you're dead in the water. So you've got to make sure that once I did that, that the plan itself provides for certain things. So you don't want to, and in that situation, it's telling me what's required, so I got to do that. But let's say that it said you don't have to do that, then I need to look at the plan to see if the plan requires me to do it or whether it doesn't. So you've got to be careful.
The other critical thing is that fourth bullet in, let's say you've been looking and looking and looking and you can't find an answer. The answer might be in the plan document.
That's right.
In that the IRS will let you put rules in there that aren't necessarily in the statute and code, and the answer may be in your document. You wouldn't even have to do the research.
That's right. And a good example of this would be, lots of times people say to me, what does my compensation have to be for non-discrimination testing? And the law allows you to use any definition of compensation as long as it follows 414F. But if you look in your plan document, it says your testing compensation is W-2 comp net of deferrals. You're done. That's what you have to use. You don't have any choices to make, even though you could be using something different. So you need to make sure your plan doesn't limit you any further. And now we're at our question section. Anybody? Ferris?
We had
Sure.
we had one question earlier going back to the clear definition when you talk about Title I and Title II of ERISA being part of the DOL and the IRS, but are both Title I and Title II considered ERISA?
Yes. Basically, it's sort of an odd nomenclature because ERISA was actually the act of Congress that passed in 1974, and that act had 4 titles to it. Title I, which changed U.S. Code Section 29, which is where the Department of Labor rules work. Title II, which changed U.S. Code Section 26, which is the Internal Revenue Code. And then Title III, which dealt with procedural issues, and Title IV, which talked about plan terminations of pension plans. All of that is law, and all of it is part of that law called ERISA. For some bizarre reason, people who deal mostly in the DOL stuff, in Title I, will generally refer to the law as ERISA and will refer to their part of the law as Title I. People who mostly deal with the Internal Revenue Code, on the other hand, never use the word ERISA and always talk just about the Internal Revenue Code. So it ends up being sort of this weird nomenclature thing. So I'll call myself an ERISA attorney because that's the way I'm known in the industry. But when I'm dealing with Title I, I'll talk about this as found in ERISA, and when I'm dealing with code stuff, I'll talk about it being in the code because nobody talks about Title II. It's just not part of the general vernacular.
Okay. All right, thank you. And then we had another question that was requesting a review of your comments on open MEPS.
Oh, okay. Well, you actually made the comment. Let me be clear on something, just because I thought about it when you said it, and that's that open MEPs are not illegal. It's just the Department of Labor does not recognize an open MEP as a multiple employer plan. So if you're trying to get one 5500 or trying to get, one audit of the plan done, if you have a MEP that is a plan that's set up by a practitioner for a bunch of unrelated clients, the Department of Labor will treat that as a series of individual plans, whereas the IRS is happy to treat it as one big plan, which produces some of the problems that poor open MEPs have been having over the past number of years. And did I talk over you on that? Did you have anything else you wanted to add?
No, that's
okay. Okay. So somebody there was from an open MEP company and had a heart attack. Give them oxygen. It'll be fine.
Any other questions?
I think we were able to answer all the questions, but if there are any additional questions, please, feel free to send us an email, support@erisapedia.com. Also, Tim, you were going to explain this, I think, about the certificate.
Oh, well, people will be getting a email with a PDF. For those that stayed on for the 50 minutes, you'll each be getting a certificate. The ASPA will want to go out soon, maybe the next day or two. IRPA, I think it takes a little while longer to get that sent to IRS. So just be on the lookout in the next couple days to get them.
And also, if you like this, you didn't like it, you'd like to see more, you'd like to see less, whatever it is, please feel free to email us at either our individual emails or at the ERISApedia email, and we'll take your comments to heart. I hope this was helpful to y'all.
Yeah, thank you, Eileen and Tim.
Yep, and this is the end of the CE portion.
Right.
So those of you who just wanted the CE are free to go.
Yeah, we're just going to stay online here for a few more minutes, so anyone who might be interested can see a brief demo. I promise we won't go as fast as Eileen did. Her brain even works faster than I think the computer could keep up. But if you can't stay online, if we've already outstayed our welcome, we'll be glad to do a personal demo for you at your convenience. Again, just write us at either sales@erisapedia or support@erisapedia. Thank everybody for attending. Have a great day, and those of you going to stay on for the demo will be starting very shortly. Thanks.